Good evening, ma'am. Myself, Abhinav from Team 7. Our teammates are Lalit from Auto, Abhishek from CSC, Sai from CSC, Litesh from Auto, and myself, Abhinav from CSC, Virendra from Auto. We are doing an activity on legislative measures in industrial safety, which means the measures taken by the government regarding the safety of workers who are working in the industries and regarding the industrial safety and regarding the measures which we have to use in industries. Let's get into the presentation. The Constitution of India introduces the detailed provisions for the rights of citizens and the principles to be followed by the states in the governance of the country. These principles are called as directive principles of the state policy. These directive principles are introduced for securing the health of workers who are working in the industries, both men and women, and ensuring that children are not abused in the teenage. For example, if we take an act called Industrial Safety and Health Act, it deals with the all aspects of health and safety in the workplace and has a strong focus on primary prevention of hazards. Its main goal is to prevent the accidents and harm to people from work related activities. And these principles are committed to regulate all economic activities among the states and with foreign nations for the management of occupational safety and health risks, and to provide the measures for protection of the national assets.
Hello ma'am, this is Lalit Sanjay from Automobile Department. Previously, my fellow teammate Arnav Krishna has told about the brief points in the legislative measures in industrial safety. Now I am going to take about the laws and different type of acts present in this project. First one, laws related to working hours, condition of services and employment. In this, we have taken two types of acts. Basically, the first one is the Factories Act in 1948. This is an act to consolidate and amend the law regulating labor in factories. It came into force on the 1st April of 1949 as the Factories Act, and it was extended to the whole India. This act provides for the health, safety, welfare, and other aspects of OHS workers in the factories. It is also enforced by the state government through their factory inspectors. It allows each state to frame their own rules so that local conditions in the state can also reflect in the enforcement. This makes more advantages through the amendment, like for the opportunities can be morely utilized, and also it punishment of this amendment is can be provided more strictly than before. This act also sanctions interference with the ordinary rights of the citizen, which is an unquestionable power that was given to this act. And the second act is the Mines Act in the 1952. This is an act to amend and consolidate the law relating to the regulations of labor and safety in mines, and it is also extended to the whole of India. Basically, the Indian Mine Act was related to the regulations and inspections of the mines was passed in 1923 itself. But due to some technical issues and the experiences faced by this act was faced by this act revealed a number of defects and deficiencies which questioned the government sectors, so that they formed again a new form of controls and tightened the existing legal provisions and overhaul the existing act and reconsolidate this law in 1952. The main obligations of this act are the formation of a safety committee in each and every mine where more than 100% are employed, and providing a notification of accident previously, and appointment of a workman inspector by the manager. Based on this act, uh, recruiting adolescents below the age of 15 years is strictly punishable offense, and it was strictly prohibited. For any mining operations, the adolescents cannot be entered in the mines. Before entering into the mines, the initial and periodical examination of miners is to be conducted, and notice has to be provided for any noticeable diseases for this act. Thank you, ma'am.
Hello, ma'am. This is AM Abhishek from CSC department. After my friend Lalit Sanjay has explained his topic, now I'm gonna take over to my slide. And my slide is laws related to equality and empowerment of women. The first point is the Maternity Benefit Act 1961, an act to regulate the employment of women in certain establishments for certain periods before and after childbirth and to provide for maternity benefit and a certain another benefits. And the second topic is application of act. It is applicable to every establishment being of factory, mine or plantation, including and such establishment belonging to government, and to every establishment wherein persons are employed for the exhibition of equestrian, acrobatic and other performance. Every shop or establishment within the meaning of any law for the time being in force in relation to shops and establishment in a state in which 10 or more persons are employed or were employed on any day of the preceding 12 months. Employment of or work by women prohibited during certain period. And the first point is no employee shall knowingly employ a woman in any establishment during the 6 weeks immediately following the day of her delivery or her miscarriage. And the second point is no woman shall work in any establishment during the 6 weeks immediately following the day of her delivery or her miscarriage. The third point is without prejudice of the provisions of section 6, no pregnant woman shall, on a request being made by her in the behalf, be required by her employer to do during the period specific in subsection.
Hello everyone, this is Ritesh from Auto 5A. My topic is legislative measures in industrial safety. I want to share a few words about laws related to equality and empowerment of children. The Child Labor Prohibition and Regulation Act 1986, an act to prohibit the engagement of children in certain occupations and to regulate the conditions of work of children in certain other occupations. It extends to the whole of India, provided that nothing in this section shall apply to any workshop wherein any process is carried on by the occupier with the aid of his family, or to any school established by or receiving assistance or recognition from government. Laws related to Social Security. The Workmen's Compensation Act 1923. Workers' compensation laws protect people who become injured or disabled while working at their jobs. The laws provide the injured workers with fixed monetary awards in an attempt to eliminate the need for litigation. These laws also provide benefits for dependents of those workers who are killed because of work-related accidents or illnesses. Some laws also protect employers and fellow workers by limiting the amount an injured employee can recover from an employer and by eliminating the liability of co-workers in most accidents. State statutes establish this framework for most employment. Federal statutes are limited to federal employees or those workers employed in some significant aspects of interest commerce. Thank you.
I am Vandan Sai from CSE department. Previously, my teammate explained our project. Now I explain about laws related to labor welfare. The Mica Mines Labor Welfare Fund Act since 1946, an act to constitute a fund for the financing of activities to promote the welfare of labor employed in the mica mining industry, whereas it is expedient to constitute a fund for the financing of activities to promote the welfare of labor employed in the mica mining industry, the improvement of public health and sanitation, the prevention of disease, and the provision and improvement of medical facilities, the provision and improvement of water supplies and facilities for washing, the provision and improvement of educational faculties. Thank you, ma'am.
Hello everyone, this is Virendra from Auto 5A. Our topic is legislative measures in industrial safety. I wanna share about laws related to employment and training. The Apprenticeships Act 1961. The main purpose of the act is to provide practical training to technically qualified persons in various trades. The appointment of apprentices may be for designated trade or optional trades. In addition to designated trade, an employer is free to have optional trades. It shall come into force on such day too, as the central government may be notification in the official gazette appoint, and different dates may be appointed for different states. The provisions of this Act shall not apply to any area or to any industry in any area unless the central government by notification in the official gazette specifies that area or industry as an area or industry to which the said provisions shall apply with effect from such date as may be mentioned in the notification. The Fatal Accidents Act 1855. The Fatal Accidents Act, as amended, now enables a person who was living with the deceased as husband and wife or civil partners immediately before the date of the death and had been living with the deceased for at least 2 years before that date to claim such damages. An act to provide compensation to families for loss occasioned by the death of a person caused by actionable wrong. This act is based on the Fatal Accident Act 1846. This act has been declared to be in force in the whole of British India, except as regards the scheduled districts by the Local Extent Act 1874.